Yeah, sorry, I missed him. I suddenly got panicked and rushed off. I forgot he wasn't coming down. Right. Okie doke, so that will give me an hour, right? I'll leave you 15 minutes.
That's fine. I'm not going to have to make the same point 3 times in response to your powerful submissions. So.
Court rise.
My lords, before the short adjournment, we had the Hasbro case open, which is in the JA bundle.
Tab 16, yeah.
Indeed, we were at page 477 because we were looking at paragraphs 42 to 44.
Yes.
These being the specific paragraphs that have been pulled out and were referenced in Sky. Since we have it open, to save us going back to it later on, could I ask you to turn to page 479? So, my lords probably appreciate that the context of this dispute is an allegation of evergreening. And it's being explained, paragraphs 69 to 71, how the court is viewing the Board of Appeal's reasoning. And at 69, it's summarising that reasoning. And it's explaining that the reasoning unambiguously shows that it is not the fact that an EU trademark is refiled that was found to be indicative of bad faith on the part of the applicant, but the fact that the information in the case file showed that the applicant had intentionally sought to circumvent a fundamental rule of EU trademark law, namely that relating to proof of use, in order to derive an advantage therefrom to the detriment of the balance of the EU trademark system established in the EU legislature. In other words, it wasn't the mere refiling that was the problem. It was the further information that the purpose of the refiling was not to achieve, in particular, the origin identification function, but as my Lord Justice Arnold indicates, there are other functions to a trademark. But in this particular case, as we see at 71, it was the applicant's own admission that the purpose of the refiling was effectively to avoid the administrative burden of having to prove that they had made use of earlier registrations. It was, in that case, the confession coupled with the...
Well, it was the applicant's view that there was nothing wrong with that.
Indeed.
Because they thought, well, you get a 5-year grace period.
Yes.
And were entitled, under the system, to repeatedly use that 5-year grace period.
And they were told not.
Indeed.
And indeed, they, I think, had gone further than saying simply that there is permission to refile whenever you want to refile. They had said it's positively an acceptable basis on which to refile. Indeed. Not that you are worried about non-use, but you just want to avoid having to prove non-use.
Exactly.
Because in their case, it being this very old and famous mark, monopoly, they considered that to be an excessive administrative burden. And indeed, one of the points that they tried to make to the court in that case, or indeed to the EU IPO, was, and I'm going to paraphrase here, come on, it's monopoly. Do we really have to go through this every time? Surely we can get away with it. It's understandable in our case. But that's not why I draw it to your attention. I draw it to your attention because the raw fact of the refiling was not alone the problem. It was coupled with the explanation that they give. And of course, that's something that we will see again in the cases that my Lord Justice Arnold drew to our attention in the course of his judgment in Liddell. So if I could ask you to go back to that, and that is in the same joint authorities bundle, but now we are back behind tab 23. And here we are moving to the explanation for why the disposal of the bad faith allegation at the interim stage was rejected. And beginning at paragraph 38 is a discussion of 3 cases, all of which are concerned with the issue of defensive marks. I appreciate, again, I'm telling some people what they already know, but just to make sure that we're all on the same page. At paragraph 38 is discussion of Il Ponte Finanziaria, and that is being entered to explain that there was a stage at which, in some EU countries, defensive marks were okay. And the question arose, are they okay under the EU system? And Il Ponte Finanziaria says they are not. Then we turn to two UK judgments. So at 39 is given an example of a defensive registration that was held to have been applied for in bad faith, and it is what I'm calling the Kinder Snappy case. And as is explained in the quoted paragraph under 40 in the Liddell judgment, the allegation that was made, and I'm obviously paraphrasing, my lords will read the full thing, registrations had been made without an intention to use, but to extend protection for part of the mark without an intention to genuinely use, and that could be seen from the fact that there had been no genuine use. Moreover, the focus of these extra registrations was on a word that was otherwise unregisterable because descriptive, namely the word Kinder. Now, importantly, in my submission, at paragraph 41, what is said is that the proprietor did not answer the allegation. There was no evidence of use of the challenged registrations. And therefore, at 42, it was held that the prima facie inference, the allegation that we see set out at 40, had not even been answered, and so was accepted. Now, we say here that that is not simply a question of the failure on the part of the proprietor to provide any evidence in response. The very failure to respond at all led to its own inference, namely that they couldn't respond because they had no good answer. It is, in my submission, therefore, a manifestation in part of the principle to which we referred earlier and is set out in my skeleton argument on this appeal in footnote 4, namely the principle in Blatch and Archer that you produce the evidence to the best of your availability. Here, nothing was said. No answer was made at all. And so, both by silence and by the inference that could be drawn from the silence, we say that the conclusion of Mr. Kitchen, as he then was, is entirely understandable. The next case considered is that of Target Ventures at 44. In that case, as the quoted passage at paragraph 45 of Liddell makes clear, the proprietor acknowledged that the application in question was a defensive one, namely that the purpose of Target Ventures was not to serve as its own indication of origin, but to widen the moat around target partners. Indeed, it was expressly and openly said by the applicant to be a defensive mark, and that was therefore held to be bad faith. And so in that sense here, like in Hasbro, bad faith was found on the basis of the express statement from the applicant as to their motivation, that motivation being held to be contrary to the purpose of a trademark registration. They did not understand it to be independently distinctive. They did not intend to use it as a basis for creating or maintaining a market under goods and services for which it had been specified under the sign. It was just to help them to protect what they were really using, because the additional words were ones that, like in Kinder, they would have struggled to register. Now, the conclusion on appeal in the Liddell case was that the facts, the admitted facts, suggested a potential form of bad faith was a possibility. It couldn't be dismissed at the interim stage, much as in Kinder, an allegation had been made that needed to be addressed. It required investigation. Now, it might be that nothing was then proffered in response, as in the Kinder case. It might be that what was revealed in response amounted to a confession of something that the court would hold was bad faith. But either way, until that response or absence of response was known, a trial was needed. Now, for completeness, let me simply note that the court also considered that the evergreening allegation could not be dismissed at the interim stage. And that, as we understand it, is because, as the reference of paragraph 47 makes clear, the purpose of the refiling could be illegitimate. And as in Hasbro, although the mere fact of refiling was not enough on its own, it nonetheless required potentially some answer, particularly in the context of the other matters that arose. And indeed, it's possible that, as in Hasbro, the answer that came back may be an answer that was an admission of illegitimacy of some form or another. Now, unsurprisingly, this judgment, we say, provides much of the principle that was to be applied. So therefore, may I only very quickly reference two other cases to frame my submissions. One of them is a judgment called Pelican. It's a judgment of the General Court of the European Union. It is at tab 29, which is in the smaller of the two JA bundles, and it is page 887. And what I will ask the court to take from this authority is a clear emphasis that facts consistent with both good and bad faith are not sufficient in themselves to found a finding of bad faith, and that the court should not find bad faith simply on the basis of speculation as to the subjective motivation of the applicant. Now, this was also an appeal from the EU IPO. It concerned an application to register the sign Pelican, and one sees that over on page 888 at the top. And the list of goods and services is set out below, but there was a pre-existing mark of the applicant, and one sees that on the opposite page under paragraph 5, which was registered for goods set out under paragraph 6. And here, again, there was an allegation of evergreening, and that therefore this was a bad faith registration. And the General Court begins to consider the issues over on page 891 at the passage that has been sidelined, paragraph 20. And it begins with reference to the Lint case, which in our submission remains a touchstone for consideration of bad faith, as we have seen in Sky King. The particular allegation of bad faith is set out at 23, essentially that the contested community trademark is practically identical to the earlier community trademarks. My lords see that from the images on the previous page, and covers services in classes 35 and 39, in respect of which community trademark 179226 was revoked. The application for registration of that mark amounts to a repeat application intended to prevent loss of the rights attaching to the earlier community trademark which had not been actually used. The General Court looks at the two specifications, and its conclusions begin at paragraph 33 over the page on 892. First, it observes, this is 34, that the mere fact that the signs are identical cannot alone establish bad faith.
Well, they weren't identical, they were in fact different, but the differences they held would not be noticeable by the average consumer.
Indeed, my lord, that's an example of my problem of knowledge. They had considered the question of whether or not they could be treated as effectively identical by reference to the case law on when you're entitled to do that, and that they're framing the debate on the basis that there isn't a material difference.
Yeah, I mean, so as they point out, one difference was one chick or two chicks.
Indeed. Although there was some debate as to whether or not that one chick or two chick issue is just a matter of bad printing in the first one. But I understand. I mean, amongst myself and my juniors. But at any rate, at 35, it notes that there had been an updating to the sign, and that led to a decision to refile. And then at 43. It identifies factors relevant to the assessment of bad faith, and among them is that use has been made of the sign since its creation. At 48, it addresses an allegation that Pelican should have anticipated an application for non-use revocation of its earlier mark, and in dismissing it explains that mere speculation is insufficient to establish bad faith. As we see at 50, even the timing of the new application relative to the date of the expiry of the grace period was not sufficient to warrant a finding of bad faith. Indeed, this is a point that the General Court returns to in dismissing the allegation of bad faith as being predicated on the size and overlap of the specification. You see that at paragraph 60. Evidence was needed, evidence was lacking, no bad faith. Finally, my lords, may I take you to this court's judgment in Sky King?
So what do we get out of Pelican, which looks as though it's a decision on the facts?
It is very much a decision on the facts. That what I ask you to get out of it is the clear emphasis that facts consistent with both good and bad faith are not sufficient in themselves to found a finding of bad faith, and that the court should not find bad faith on the basis of speculation as to the subjective motivation of the applicant. So I've drawn it to your attention partly because one can see how, in the context of a particular allegation which has clear analogies for the later evergreening allegations in this one, that at least in this context the General Court has addressed matters and how it has held the idea of the cogent evidence to be applicable to the particular facts there. Sky Kick in the Court of Appeal, my lords, this I will deal with very briefly. It is at page 1156 in the Joint Authorities bundle. I deal with it very briefly because it's both well known, and of course my Lord Justice Arnold and Lewisham reference it as the basis of their reasoning in the Little case that we've already looked at. So all that I am doing here is just drawing out what is said at page 1156 by Sir Christopher in paragraphs 79 and 80. At 79 he refers to a judgment of Daniel Alexander, you see, and you see the quote that is given. The bit that I am interested in for these purposes is paragraph 22. It's therefore appropriate for the relevant tribunal to consider in particular, in any case where bad faith is alleged, whether at the date of the application, having regard to the chronology and all the circumstances, my lords understand that that's part of my submission on whether or not the judge required a particular kind of evidence. We say it's all of the circumstances. The applicant had a commercial reason to register the mark at all, or to register it for the goods or services applied for, on the basis of an arguable claim to legitimate protection of its actual or potentially extended future business under the mark. And those words, we say, echo what was said in Hasbro as to the kind of evidence that's required once the evidential burden shifts. And it is concluded by what we say is a submission, by an observation by Sir Christopher at paragraph 80. The caution that we say he sets out there is justified by and consistent with the serious nature of the allegation, and all the authorities prior to this one, and indeed in our submission, is likely to survive any judgment of the Supreme Court. Now, my Lord Justice Arnold has in a number of cases often noted the potential bloat in trademark registries, and that the bad faith provisions are a tool capable of addressing some of that issue. But in the context of this caution, we do say that it is a specific tool directed not to the question of bloat as such, but to bad faith. And the problem of bloat in the registry is a question of policy, ultimately, that should be dealt with by politicians.
Just so as we're clear, by bloat I understand you're referring to what the academics call cluttering.
I am. Of which I know that you've made express reference in your explanation as to why bad faith is an appropriate tool for considering issues such as registration by reference to so broad a specification it couldn't possibly be the case that the parties intend to use it. But what I'm setting here is the note of caution of Sir Christopher's against the acknowledgement that there is a problem in the IPO and the tool that the court is deploying to deal with. Lastly, my lords, not an authority, but just a point on the Trademarks Act. It's conveniently set out in the judgment that we are to consider, which is in Core Bundle B at 214, which is on page 620.
You say 214?
Yes, paragraph 214, page 620, Core Bundle B. It's part of judgment, not on bad faith, but on the issue of whether the wordless mark had distinctive character. And my Lord Justice Arnold will anticipate why I'm drawing attention to it, but the reason I'm drawing attention to it is to make the submission I've made before, which is that the Act expressly contemplates that there may be use by reference to a trademark that is itself also separately registered, and that therefore that is not inherently objectionable. The objection must lie in something else. It must lie in the subjective motivation. It must lie in the defensiveness which underlies the registration, not in the nature of the mark itself.
So that would require the form of the mark with text not to alter the wordless, not to alter the distinctive character of the wordless mark. Is that right?
I think you're right, my lord, but I'd probably put it the other way round. The wordless mark's character must not be altered by the fact it is being used in the form of the mark with text. I hope I've understood that correct, at least answered what my lord was asking. And as I say, my point is...
what that means, Mr. Van.
Well, so defensive marks are objectionable. No debate about that. But is it objectionable in and of itself to apply for and register a mark that is entirely subsumed within an existing mark on the register? We submit no, because not least one can see the Act expressly contemplates that that might be possible. Therefore, what must be looked for, and as I understand it from the little judgment, is the requirement that was put upon us, is something that indicates that this is not just what's contemplated as permissible, but actually motivated by the idea that it's a defensive mark.
So, but if we just track section 46(2),
Yes.
we're talking about registration of the wordless mark.
Yes.
So that is the trademark that's referred to in 46(2). So use of the wordless mark includes use in a form that is the mark with text, differing in elements, which it does because it's got text in it, which do not alter the distinctive character of the wordless mark. So that's the question.
Yeah. And that's what the judge addresses herself to in this context.
And she decides it in your favour.
Exactly.
But can I go back to something you said before? I'm not sure it matters in the slightest bit, but I'm puzzled. I therefore want to eliminate the puzzlement. You referred to there being no objection to registration of a mark which is subsumed within a mark which is already on the register. Now, I may have got the chronology backwards in my head, but I thought that so far as retail services were concerned, the wordless mark was in fact registered first. Is that wrong?
Well, the answer to that...
There was an earlier registration of the mark with text in Class 32.
Yes.
And you will recall, and my Lord Justice Lewison will recall, but I better state it for those who weren't present, there was a lot of debate on that on the previous occasion about the fact that neither side had pleaded the Class 32 registration, even though the judge had found it, and of course being a registration, it was a matter of public record.
Yes.
Now, is my memory at fault?
No, your memory isn't at fault there. But the reason that I'm drawing it to the court's attention is because one of the admitted facts that is said to have been relevant is that the mark with text existed and was being used and had been registered, albeit for a subset initially of what was later registered for the wordless mark. And that question, we say, alone is not enough because the Act contemplates that you might wish to do that. And I'm going to explain that you will see here why one would want to do that in this particular context. But that what my Lord was saying is you've got to come and give that explanation because there is the possibility that the reason that you used a subsumed mark, if I put it that way, is that you were looking for something defensive. And in this particular case, because you've admitted that the mark is intended to extend protection, I particularly want to know whether that is the case. And because it is said you haven't made use of it, well, that also is a reason why I want to know whether that's said to be the case. But what I'm trying to tease out is that there's no inherent bad faith in your mark being something that is already registered, a subset of something your mark is already registered for, provided that you then make use of it in a way that doesn't alter the distinctive character.
Isn't it, you don't need to answer this question now, Mr.
Yes.
Brandreth, but can I just make it clear to you that I'm not sure that I think that that proposition isn't too widely stated. Because I can quite understand why, for example, it is obvious that if you had registered Lidl, the word mark Lidl, which is in fact subsumed into the mark with text,
Yes.
we wouldn't be here. So simply characterising the application in issue as an application which is subsumed into another one,
Yes.
as if that acts as a trump card to say that you just don't get involved in bad faith, isn't right.
We're definitely.
So the point I want to make is that by characterising this as merely a mark which is subsumed into another mark doesn't get you home.
We're definite cross purposes, my lord, because what I'm trying to say is it's not a trump card the other way round. It's not a trump card that means there must be bad faith. I fully agree with you, my lord. It isn't a trump card that there is good faith. That's certainly not what I'm trying to advance it for. To the contrary, I'm just trying to tease out the idea that it is consistent with good faith. No more than that. And equally, as my lord, Lord Justice Arnold has indicated in the Lidl appeal judgment, potentially consistent with bad faith. I'm accepting, I suppose.
Stated at that level of generality,
Yes.
merely the fact that a mark is subsumed could be consistent with good faith.
Yes.
But that doesn't mean that your mark is consistent with good faith.
Absolutely agreed. And indeed, that I understood was the whole point of where I'd gone wrong. I'd run that argument before the judge at first instance on the interim and succeeded, and I was put back in my box by the Court of Appeal. And so I'm not trying to run that again. I fully accept that. What I'm trying to emphasise is only that it is not a trump card in the opposite direction. So I think if that's what my lord is saying to me, then I'm in full agreement with it, and I'm grateful for the opportunity to clarify how I see it playing out. I may have given it too much weight. In that context, I was also going to have referenced what was said in Specsavers, in particular at paragraph 24, which expressly acknowledges as legitimate that the application and registration of a mark that is itself part of another mark is something that can be done. But that's well known. I think it's just going over the same ground. So I've set up the framework. Now let me turn to this judgment and the appeal. The judge turns to the issue of bad faith at paragraph 231. And she sets out the arguments between the parties from there up to paragraph 234. And we submit that the errors in her reasoning become manifest from 235 onwards, because there she records a legal proposition, namely that an application could have been made in bad faith because there was no intention to use it at that time, although in fact subsequently there was use. Now, as a proposition, we don't challenge that. Indeed, it is express in the Pelican case to which I took you at paragraph 58. The issue of bad faith is to be judged at the time of the application, and so in theory there could be bad faith because of no intention to use at that point, but the intention later changed. But the issue before the judge was whether she could conclude on the balance of probabilities that at the date of the application, Lidl had no intention to use. Now, in that context, what material, we ask, was before her on which she could come to that conclusion? Now, to put it in terms found in the Court of Justice's case law, what were the objective factors that led to the conclusion that on the balance of probabilities, the subjective intention of Lidl was not to use the wordless marks as a badge of origin, but simply to register them to better defend the mark text? We say only that the use relied on was in a form different to that registered, but crucially, not in a form that altered the distinctive character. On this point, the significance of the finding of use in a form that differs from that in which it is used being permitted, where it does not alter the distinctive character of the mark, is this, that such use continues to fulfill the essential function of the mark. The mark continues to act as an indication of origin. Accordingly, the fact that the mark will be used as part of another mark is, as I say, insufficient in itself when set against that express provision in the legislation.
Can I be clear as to the parameters of the debate? Because if I've understood correctly, you don't resile from the admission that was made at the previous stage of the proceedings, and in fact two of them, you mentioned them already, but just there's the point about wanting extra legal protection, you say there's nothing wrong with that. But secondly, as far as this point is concerned, it's accepted that Lidl never intended to use the mark in the form registered. You say that's immaterial because they did intend to use it in the variant form.
Yes, that is exactly what I say, and I also say that, as I will show you, that was expressed from the outset, so you can see that that was their subjective intention. Here I'm saying that the judge has gone wrong by out of hand dismissing her finding as to what had actually then gone on, not on the basis of what it could tell her.
The reason why I asked the question is this, because what I'm wondering is to what extent the issue raised by your appeal is an issue of fact, which is how you seem to be presenting it, and to what extent it is an issue of law. Because, as we've just been over, you don't dispute the starting factual proposition, which is no intention to use in the form registered. You've got a finding of the judge in your favour that there is use in the form, in the variant form, and the question is whether, it might be said, is whether in law the latter is sufficient to trump the former.
Yes.
Rather than it being a factual question of what Lidl's subjective intentions were.
And my answer is that in law it is capable of trumping the former as part of the assessment of all of the circumstances. And that what the judge appears to have erred in doing is thinking that it should be put to one side entirely because it occurred after the application date. So my lord is right that my appeal is on the facts because we say that her conclusion was rationally insupportable as a matter of fact, a finding that we had acted in bad faith. But she has forced herself into that position because she has misunderstood, we say, the implications of that interim appeal judgment as taking her to be more constrained as to what she could look at than in fact she was. Sorry, my lord.
Sorry.
Yeah.
Forgive me for forgetting. I'm sure if it's there, I've just forgotten it. Did the judge actually find against you that your client had no intention to use the mark in the variant form at the time that you applied for the wordless mark? I mean, that seems a surprising finding the judge to have reached.
Well, but that was
That sounded like that's what you're putting to me.
That was the allegation that was being made, so it must have been the basis for her finding that we had no intention to use it, but we had simply registered it as a defensive weapon. Well,
No, I'm asking the question precisely because it's not in dispute that you had no intention to use it in the form as registered. You agree with that?
Indeed.
The point you make, and I understand it, is that the point I thought you were making is that you of course intended to use it in the variant form.
Yes.
But again, if I've missed it, I'm sorry, but I don't recall the judge finding as a fact that you had no intention of using a variant form.
I think my lord is right that there is no express finding to that effect, but on the basis that the pleading of bad faith was from an inference that we had no intention to use, even in a variant form. In finding that there was bad faith, it must have flowed from an acceptance that that was the case at the date of the application. And as I understand it, and why I say this is where she begins to go wrong, she has dismissed her findings in relation to use in the variant form because she understands that they can't help her to inform what was going on at the date of the application. And that's why I think my Lord Justice Arnold was putting to me the question of whether or not, as a legal proposition, can that later activity assist, in particular the finding that there's been use? We say it can, it's not decisive, but it is part of the circumstances that should have been taken into account. My Lord's still looking.
Not to worry, keep going, Mr. Brown.
Well,
I do slightly worry,
my Lord's helpful question
Yes. Very high.
highlights then that we've got two questions in play,
Yes.
and one is actual use subsequent to the date,
Yes.
which has been held essentially as a matter of law to qualify as
Yes.
use of the wordless mark.
Yes.
And that seems to be what the judge is addressing at 235,
Yes.
which is actual use doesn't disprove bad faith, to put it crudely. And I appreciate you say that's the wrong way round, but then there's this different question, which my Lord highlights, which is whether there's an intention, as at the application date, to use in the variant form.
Yes.
And that, again, that's different again, isn't it?
Yes, but as I understood what my lord was concerned about, let me put it this way. If the judge had understood that my client had an intention to use it in the variant form in a way that would amount to genuine use, therefore not as a defensive mark, hadn't applied for it as a defensive mark, she wouldn't have found bad faith.
Well, that's where Hyde Park Company reviews
Yeah.
Mr. Brown.
Yes,
See,
okay.
I mean, let's cut to the chase.
Yeah.
It looks pretty clear that there's not really any fact in dispute in this case. Your clients had no intention of using the mark in the form it was registered. What they intended to do was use it in the variant form.
Yeah.
It wasn't clear, and that's why I asked that the judge had misunderstood that.
No.
The judge does focus on the later use itself and not helping, but you've lost because an intention to use it in the variant form doesn't turn an application to apply for the mark in the wordless form, which you have no intention to use in the form as registered, into good faith. That's what this is all about. There's no fact. There's not really any facts in dispute. It's a legal question of whether that's good enough or not.
Then I was right, my lords, to indicate earlier that couldn't be a basis for bad faith because the Act expressly contemplates that kind of use is permissible.
Well, I think what the judge seems to be saying at 248, para 248 Roman 1, is that there's no evidence that Liddell knew or thought that it was using the wordless mark in the variant form.
Sorry.
That she seems to think that that's important.
Yes.
That you didn't intend to use the wordless mark as registered, and you had no idea that using it in that the use of the mark with text would, as a matter of law, amount to use of the wordless mark.
Yes, but that's why I say that the answer is that in finding bad faith, her view must have been that we had no intention to use it either in registered form or in permitted variant form, because it's only at the absence of an intention to use it for the purposes for which a trademark should be used, namely to create or maintain a market under that sign for the goods and services, that is the essential element of the bad faith on which the Tesco case, the pleaded case, relied. It is otherwise entirely consistent with good faith to have thought to yourself, I'm going to register this mark because I'm going to use it as an indication of origin, but I'm going to use it as a part of the another mark. Only if there's no such intention at all.
That's not quite what the judge is saying, though, is it? She's not saying Liddell's thought process is we're going to register the wordless mark because we're going to use it as part of the mark with text. On the contrary, she's saying you had no idea that use of the mark with text would amount to use of the wordless mark, therefore no subjective intention to use the wordless mark at all. That seems to me to be the reasoning process largely in paragraph 248.
Yeah, but that is why we do come back to the factual dispute, because she must therefore have dismissed evidential matters that showed that we had that understanding, and those are the things that I'm to turn to now. But I don't resile from my position that's based on Specsavers and 46.2, that she must have understood that there was no intention to use of any kind, not just, as my Lord Justice Burst puts it, not just that there was no thought given to it at all, because the allegation that was made by Tesco was that we had no intention to use it in any form, and that coupled with the fact that it was a subsumed mark and the other matters to which I've drawn attention was what permitted the inference and required investigation.
So, like Monsieur Jourdain, you've been speaking prose without knowing it.
Possibly. May I press on, though, my lords, just because it may become clearer once I set them within the evidence that I say she should have taken into account, and which does directly address that question. But because what we're saying is that this issue of the subsumed nature of the use that we're relying upon isn't sufficient in itself. That, we say, is indicated by point 6 in the list of principles that have been referred to and reflected in paragraph 23 in Walton. Now, of course, as in Kinder, it might not have been answered at all, but one knows, my lords, that that wasn't the case here. Or in Target Ventures, it might be met by a response along the lines, perhaps, that my Lord Justice Burst was thinking. We didn't give it any thought at all. Or something along more closely aligned to the Target Ventures or Hasbro case. We're doing it for a reason that isn't in line with the functions of a trademark, but helps us administratively. But again, that didn't happen either. What the court has seen is that the judge below found that we had, as a matter of fact, made use of it. And the basis on which he found that was...
Not as a matter of fact, as a matter of law.
Sorry, as a matter of law, but on the basis, as a matter of fact, of the usage that predated the application in question. I rely on the fact that the mark with text had been used for a decade around Europe and for a year prior to its application in the UK, because that is part of why we say that when you look at what we were saying at the time that we applied for it, we were understanding that there had been use that entitled us to some kind of protection. But at any rate, what it does provide is a plausible commercial rationale for the registration of the background, because the background had, as a result of the use of the mark with text, come to serve as an independent indication of origin. Indeed, there, I say, the judge's findings as to the nature of the mark, that it was inherently distinctive, that it shone through, should have formed part of her reasoning, because if that was her understanding of the relationship between the wordless mark and the mark with text, there was every reason to infer that that was also the understanding of the party registering it following that use. But she didn't need to infer it, they say it expressly, and I'll come to that. That is why we say that those findings in the context of distinctiveness ought to have been drawn on more fully, because they are aspects of the chronology that Mr. Alexander refers to, that support the idea that there was understood to be a separate role for the background as an indication of character, of origin. My lords will recall that in this discussion of the distinctive character of the wordless mark, part of what her ladyship draws on is that the features of the wordless mark itself is what makes it inherently distinctive. Moreover, that it was unique at the time within its field of activity. And thus, whatever the initial facts may suggest, the admitted facts, the finding of use in the terms in which she has put it is not consistent with the interpretation of that initial fact as indicative of a bad faith by defensive registration. What happened following the application is, we say, admissible and probative of what Liddell thought was going on, and that is the basis we set out as ground 5 in our appeal. It's plainly right, we say, that subsequent use, though not determinative of the question of what the mindset was at the time of the application, does not mean that it can be, as it was, dismissed entirely. Now, you have to give consideration in our submission, but the judge does not, to the significance of the fact that the use that we relied upon predates that application. It was made following the use of the kind that the judge held led to acquired distinctiveness for that sign. We go further. Can I take you to the matters that were set out in the statement of case on good faith? The first is the application, which can be seen, let me contextualise it by showing you the first application, which is in the schedule at Core Bundle A, tab 6, page 123. This is just a convenient collection of the marks that were in issue. You can see the signs across the third row. You can see the territory in the second row. And then set out below that by reference to the classes are the registrations. And for this purpose, let me begin by focusing on the one on the far left, which is the 1995 registration, the UK registration, which was filed in black and white, the colours merely being shown in hatching. That was customary from the time before trademark journals were published in colour copies. Now, the statement of case on good faith makes it clear that Lidl was just beginning its international expansion at this time. It had begun in Germany in 1973, it first opened in France in 1989, Italy then in 1992, and it's now opening in the UK in 1994. And at this point, the community trademark system is brand new. Lidl is still filing individual national trademarks.
Can I just check, going back to what you were saying before, just to again to avoid confusion, I don't think it matters, but at the previous stage of the proceedings, both parties proceeded on the basis that the heraldic shading could be treated as if it were a contemporary registration in colour, albeit of that day.
Yes, and I don't resile from the idea that these signs are materially the same. I don't say that that's completely irrelevant, because as you will have seen from the Pelican case, the General Court was prepared to take into account the need to update the registration to reflect the latest version of the sign as being one of the plausible commercial reasons for a change being made. But even so, that cannot have materially changed the signs. They must, we submit, be the same in the sense that Pelican treated them to be the same. Now, I wanted to pause here, my lords, because it's a convenient opportunity to make a particular point, which is indeed the point that I've just made about Pelican. Now, this is a sign that was applied for 30 years ago. So, returning to the Blatch and Archer principle, it's surprising that there are any surviving documents or live testimony from that time for my corporate client. And as I submit to you, it is not a requirement of the authorities that only such evidence
We don't know that there are no surviving documents, do we? Because there was a claim to privilege, and you're perfectly entitled to claim privilege, and no inference can be drawn from the claim to privilege. But because of the claim to privilege, we don't know that there are no documents, do we?
My lord, that's not my point. We know there are documents. I'm going to take you to them. Because it's surprising that there were any. My submission at this point is not were there or weren't there any. My submission is that we're lucky that there were some on this occasion. Now, my lord refers to the fact that there were privileged materials, but of course my client isn't waiving privilege, and no inference can be drawn from the fact that it waives privilege. My submission at this point is only about the nature of the evidence that is required. It cannot be that it is only direct testimony from live witnesses that is sufficient. Because were that so, the older the mark, and particularly in corporate scenarios, the less likely you are to have the kind of evidence that is needed. What is necessary is that you bring forward that which you do have. There is, in this case, a surviving record. Not only that the mark was intended to be used, but that it was intended to be used in precisely the way that it was then used. And we, for that, need to go to Supplemental Bundle A and tab 12, page 169. These are all references that I'm taking from the statement of case on good faith, my lord, and this is correspondence between the Patent Office and Lidl's trademark attorneys from 12th of April 1996, after the application has been made and in response to objections that have been raised by the IPA. Under the heading at Class 3, you will see it's being explained in response to a query by the Patent Office. With regards to the specification of goods, the applicant confirms that it does have a genuine intention to use the mark across the width of the specification. The attorney then goes on to specify not just a mere assertion, but also the corporate rationale for doing so, because it explains, in this respect, the applicant is part of a discount market akin to a supermarket and thus sells an extremely wide range of products.
But that's about width of specification. What's that got to do with it?
It's not addressing the specific issue of whether or not we were going to use it in the form. But what it is doing is explaining why it is that we are registering for this specification of goods in the context of a statement that we intend to make use of it. That there is a genuine intention to use. I'm not drawing it to your attention because the challenge against me is of the kind in Skykick, namely specification of goods. I'm drawing it to your attention because the intention to use is being done as part of a thought process as to which particular goods and services should be registered for, because they know that they ought to be used in respect of ones that are part of the commercial activity of the business. That, we say, is plainly relevant to the question of whether or not they understood that this was something that was going to be used.
Well, I'm trying to establish what you're actually relying upon, and forgive me if I'm caricaturing your arguments, not intended. I think the point you're making is here is an unequivocal statement of an intention to use the mark.
Yes.
But what does that add to the statement that you're required to make on the application form? And why do either of those statements help you? Because the counter-argument is it just makes the case on bad faith worse because those statements were false, because you didn't intend to use the mark as registered, and then that brings us back to the debate we had before.
Well, the answer, first of all, is that both the intention to use and this statement were dismissed as mere trademark minutiae, rather than, as we say, they should have been taken to be express statements of the subjective intention of the applicant at the time.
It's not a very accurate statement of the express intention of the applicant at the time if that intention included, as is now common ground, no intention to use the mark in the form as registered.
And we return to the point that you don't have to have an intention to use in the form of the mark as
That's not the
registered.
question, Mr. Brandreth. The question is whether this is an accurate reflection of the intention that is now admitted your clients had at the time, which is that they did have no intention to use the mark in the form as registered. The incautious reader of this letter might think that it was a statement that you did have an intention to use the mark in the form as registered.
Sure, my lord. But that's because I'm on the first page of the materials I
Okay.
want to take you.
Very good.
But my lord, allow me to build up a picture. And one of the points that we do make here is that you have to have the whole picture in mind, because it is all the circumstances, including such matters as the chronology, to which you must have regard, before you find that my client has acted in a way that was commercially dishonest. Now, one of the issues that was being raised against me at the interim stage was there anything here? And what you do not see is either silence or, my lord, an explanation in the terms that was held in Hasbro or Target Ventures to be unacceptable. To the contrary, you see at least an express statement that they want to use it for the purpose of identifying the origin of a set of goods and services they have thought about because it reflects their business. Now, my lord's quite right. Let me move on. This is but a part of the picture.
Let's have the next brushstroke.
And as I say, indeed, as I say, part of the problem we say arises here is that if you are looking for and require as acceptable only a single statement of the kind that encompasses exactly the allegation of bad faith that is made 30 years later, then you are setting the bar too high, higher, we say, than is required by the authorities, and indeed putting the burden on the party who is presumed to have acted in good faith. Class 11, my lords, on the following page, 170. Here, a response is being given to an objection on the basis of another mark, the word mark electrohelios. And what I draw your attention to is that the explanation that is given for why this objection should not stand is that the mark applied for, i.e. the one that we are concerned with, is a distinctive colour combination, including an extra ring around the central circle. In other words, the reason that they advance that it should be registrable is because it carries inherent distinctive character. Now again, we say that is part of the overall picture. The subjective understanding of the applicant at the time is that the mark that is being applied for has precisely the kind of distinctive inherent character that the judge later found shone through the mark with text, the use that was intended. And we say again that that is pertinent to the overall assessment of what they understood they were achieving by the registration, not, as we had seen with the defensive mark, that its sole purpose was to protect another mark, but rather that it itself had an inherent distinctive character, and that was the basis on which it should be registered, even though there was another mark in issue. Now I pause there because this is a point that my Lord Justice Arnold had specifically identified as a question to be answered at the full trial in the Liddell judgment at paragraph 49. What, it was asked, was the understanding at the time of the reputation and the distinctiveness of the wordless mark. Well, one point we've already made, which is about the chronology. The very acts that were then later said to achieve acquired distinctiveness had already begun. But here also you see that the understanding was that the mark itself had inherent distinctive character. What happened next, and this I think is the point that my Lord Justice Burse is drawing to my attention, is that the mark was met with further objections by the examiner. It was in the days before the opposition system, as we understand it, and the examiners cited marks they considered to be relevant. And you can see the marks that were cited in objection. They're gathered together in core bundle A at page 286. Can I take you to 289? Where you see the Osmeroid sign. But there were others, so for example, one can see at 291 Greens of Brighton, and indeed at 309, the very mark with text itself is identified. So what we're seeing here, we say, are various marks that are said to be of concern. And one of the ways in which you could overcome the objections was to obtain a letter of consent from the conflicting proprietor. And in this case, we have the letter from Osmeroid. It is at page 174 in supplemental A. Hopefully my lords have a letter with Osmeroid at the very top, and you can see that the application number is one of the divisionals of that application, the other parts having proceeded to grant separate. Now, we say we are in the fortunate position after all of this time that there is not only this letter, but that the letter of consent records the terms on which it was granted. And the terms it records are in the form of an undertaking which Liddell gave to Osmeroid, in terms that the yellow circle logo in question would be used in combination with the name Liddell of Liddell.
Why doesn't that make it worse? Because that was an undertaking that you would not merely that you didn't intend to, but you would not use the mark in the form registered.
Because we say that that is an intention to use it in a form that is permitted by the statute. My Lord Justice Burse said, is there anything that shows that we understood that's what we were going to do? Answer, yes. We gave an undertaking that we would do it. And we didn't think it was a problem that we would do it, because as you've already seen, we understood that the mark was distinctive. And the judge has gone on to find that we did exactly what we said we'd do, and it's distinctive both inherently and in acquired terms. And one of the reasons why it hasn't altered the distinctive character is because we are right when we say that it is inherently distinctive, and it shines through the mark of the text.
Mr. Bramble, I don't want you to be under any misapprehension.
Yes.
But speaking for myself,
Yes.
the fact the mark is distinctive doesn't strike me as being of assistance to you, because defensive marks are distinctive. That's the point of the defensive mark. The fact it's a distinctive mark doesn't seem to me to be. I mean, it may be that the way earlier parts of this case have been decided had some relevance to that question, but I can't see why you set it up as being the fact it's distinctive is somehow probative of your client's non-bad faith.
Sure.
And I don't see that.
Again, it is not the fact that it is distinctive, but the fact that my clients understood at the time that it was distinctive.
No, I don't see that makes any difference.
Because it is the question of whether or not they had a subjective motivation to register something, not to be used as an indication, not capable of being used as an indication of origin, but simply to broaden the moat. To the contrary, they say, we are going to use it. We're going to use it in precisely the way that they did go on to use it, and that we understand it is distinctive in and of itself, which supports the idea that they thought that that use that they promise to make would be sufficient to be genuine use. Recall, my lord, it is not for me or my client to prove good faith. Now, you're quite right, my lord, that you have to take all of these matters into account. But the fact that I have registered a sign that I consider to be distinctive cannot prove bad faith. The fact that I have
What proves bad faith, Mr. Brandreth?
Yes.
Or at least the question
Yes.
is whether the fact that you had no intention to use the mark in the form you registered it is what proves the bad faith. That's the question.
Yes. And I say
It's not answered by the fact that the mark is distinctive.
And if that is the proposition, I say it cannot be right.
I know you do.
because that is a use that is expressly contemplated by the statute. And that is why when one looks at the defensive marks, either the allegation that it is a defensive mark has not been answered, or it has been answered by effectively saying, yes, it is a defensive mark. Isn't that okay? To the contrary, here what has been said is, no, we're going to use it. We've thought about what we're going to use it in relation to. We think it's inherently distinctive. We're going to use it in this way with the word little across it. And that's, we say, only consistent, ultimately, with good faith. Certainly, it is not a set of objective, consistent indicia that shows that this is a defensive mark. There's nothing here, for example, along the lines of the revelations in Target or in Hasbro that says, yeah, actually, we were a bit worried about how good the mark with text was, so we thought we'd better back it up by a registration for the wordless mark. To the contrary, they say, no, we're going to use it because it's distinctive. We say that's extremely powerful. Given that, it is for them to prove that I have acted in bad faith. I'm presumed to have acted in good faith. Now, I think what underlies this, because, my lord, there is no challenge to the veracity of these statements. And we say that they provide a plausible commercial context that can be perceived from the expansion of Lidl's activity into the UK alone. That we have a plausible commercial reason for registering this. These are not minutiae of trademark law. They are stated intentions to use. My lord asked me a question earlier about the significance of section 32.3, which, of course, as my lords will know, is a requirement in the UK at least, that you state that you have an intention to use. Where does it take us? Well, we know, my lord, from Skykick at first instance, that the fact that the statement of intention to use was held to be false because of the specification's breadth, relied upon to damn, must also be capable of exculpating, or at least part, in my suspicion, of the analysis of exculpation. And here the allegation is that there should be an inference that we didn't intend to use. It's not a minutiae of trademark law that we had indicated that we did intend to use it. My Lord Justice Burst takes it further and says, well, but did you make it clear that you intended to use it in the particular form that you did then? Yes, we did.
Can I ask a question about the legal framework?
Yes.
The starting point is that a trademark proprietor is presumed to act in good faith.
Yes.
So does that do any more than cast the burden of proving bad faith onto the applicant or objector?
It's part of a general context in which, before one needs to even bring forward evidence, there must be a prima facie case.
Yes.
But it is also, I would say, part of the submission that is formed on the back of the Walton commentary, which is about the nature of the allegation in the first place.
Oh, yes, indeed.
I wouldn't go
so Tesco bear the burden of proving, I assume, on the balance of probabilities, that Lidl have acted in bad faith.
Yes.
How does a plausible explanation fit into that?
Because
I mean, either the judge accepts the plausible explanation and finds that the case of bad faith is not proven, or a judge can say, well, that's plausible, but I don't accept it, in which case the case is proven. Is it simply a defence to say, to the allegation, to say, well, here's a plausible explanation, judge, you don't need to decide whether or not you think it's true, it's plausible. Because that sounds very much, sorry to bang on, that sounds very much like a criminal burden, where the defence says, well, it's plausible I acted in self-defence, unless you, the jury, are sure that I didn't, then I'm entitled to be acquitted.
Yes.
That would be odd in civil proceedings.
The short answer is that there is only one burden of proof in civil proceedings. That's the balance of probability. And I think that's the point that my Lord Justice Arnold was pulling me up on, as if I was about to suggest otherwise. I don't think that's right. But the reason that the plausibility issue arises is because we say that the judge misunderstood what Hasbro was saying in thinking that we had to do more than simply bring forward what material we had available to us to support what we say was the plausible commercial reason. And that to the extent that the error arises, it is because the judge, we say, has effectively put too high a burden upon my client in circumstances where, although we had an evidential duty to discharge, we did not then suddenly become under a burden to prove good faith, only to provide an explanation for why things were as they were. My Lords, let me press on, because I'm still on 1995 and I want to get to 2007, but I will be able to do it. What of the acknowledgement that was made that the purpose of the registration was to expand protection? We say that in and of itself also goes nowhere. All that is meant by it is that every new registration serves to expand protection. The purpose of a trademark registration is to obtain protection where before there was none. It cannot possibly on its own permit an inference that the registration was in bad faith. But here one can see that it was understood to have independent distinctive significance and to be worthy of independent material. We therefore say that the judge was wrong to hold there was no evidence of the subjective intention of Liddell at 1995. That's ground 3 that we address in our skeleton, and is also encompassed in ground 4. The discussion that we've had captures what we say are the errors set out in ground 6 and 7 in the discussion of our skeleton, because we say that the learned judge is effectively seeking to confine the evidence to a particular form, a direct contemporaneous statement that set out the precise commercial rationale of the registration. Now, in this particular case, and I think perhaps underlying my Lord Justice Bursey's concerns, the question might be, well, why would you ever want to have such a registration at all? And the answer, to put it forward, is that we may choose to stop using the word Liddell. And so, to give you an analogy, one thinks immediately of, well, I say we think immediately, one of my juniors thought immediately of a marathon bar. There, you had a company with 2 words for the same chocolate bar, but wanted to align its position across the whole of the world. And it changed the word from marathon to Snickers, but it kept the font, the colouring and the formation. Here we have a company that is beginning to expand across Europe, and in circumstances where it cannot know for sure if it will be able to do so consistently under the word Liddell, then it must be right that, having recognised, as we say it has done in what it says here, that the corporate branding that is the wordless mark is itself indicative, they may wish to obtain protection for that, so that that at least can remain consistent across the whole of Europe. And indeed, in this particular case, my lords...
Sounds like speculation as to the applicant's intentions, and I thought you told us that speculation was impermissible.
What I'm trying to address is the idea that you could never want to do what we have done, namely to register a mark that is itself subsumed. And the answer is that here at least is a very obvious explanation. And of course one does know from the copyright case is that the signs were updated. There was Liddell, then there was Liddell Isbillig, and then Isbillig disappeared. And indeed in Unterhalter 3 there is indications that there was going to be another version of Liddell, L-I-D-E-L. But the point remains that the crucial evidence is here, that it was understood that this background element was distinctive in and of itself, and therefore an obvious explanation has nothing to do with defensiveness, is that this forms part of the essential corporate branding, and they want to retain protection for that, absent any other changes that they might make. That, my lords, is why we say, when you look at the circumstances as a whole, the judge was wrong to conclude that the burden of proof had been discharged by Tesco and a finding of bad faith for the 1995 registration was sound. It was rationally insupportable in the light of the documents and her own findings. That then brings me to the 2002 application. And for that, my lords, we need to go to core bundle A, where at tab 5, we have the statement of case on good faith, and at paragraph 21, is an explanation given of the process of Lidl's international expansion, and that it has opened in at least 40 EU countries. The community trademark system is by that stage also much more developed, and Lidl is filing its first community trademark. Now, that is the second of the applications that was challenged here. I've already shown you the table of them. In our submission, the starting point for the analysis should have been all the matters that I've already pointed to in relation to the 1995 application, because we submit they inform the understanding of the subjective intention of Lidl. As to the evergreening applications, for this particular sign, this particular registration, I say, we submit that they add nothing, because the 2002 application is not duplicative at all. It's not just different as to the particulars of the sign, but it is, of course, a different territory, different scope of goods and services, different legal jurisdiction in which it subsists. And the commercial rationale can be derived from the context. It was the first EU trademark, it was at a time when the business had become truly widespread, and it was the first mark with a proper colour representation. Again, over 2 decades ago, my lords, but by chance there happens to be some surviving contemporaneous evidence of Lidl's state of mind at the time, and that can be found in core bundle A, again behind tab 5 at page 113 and paragraph 22, because here there is discussion of what happened at the US Patent and Trademark Office, where there was registration in the USA of the same wordless mark, or the same sign, I should say, of the wordless mark, obviously, a different trademark. Now, Lidl's plans for expansions in North America were unsuccessful, but it had filed the trademark in advance, and US practice makes it necessary to state a basis of filing for that application when making that filing. And Lidl's basis of filing was that it had used the mark already and was using it in the European Union. That is what you see referred to at subparagraph B. If you then look at subparagraph C, just to be clear, the request for evidence was from 2002, but the response was given in 2004. But if you see what's said there, they asked us to file evidence of use that we were making in Germany of the wordless mark. And in response to that request, we do make a filing, 14 pages of advertisements, and you see a selection of them over the page at the top of 114. And what you see is that the use that we are advancing to the US Patent Office is use in the form of the mark with text. We've been asked to show use of the wordless mark. We have responded by providing precisely the kind of use that we said we would make in that undertaking to Osmeroid, and that we say is entirely permissible. We say that, therefore, is also demonstrative of our state of mind at the time. It's contemporaneous, and it reflects the idea that our mindset has not changed since 1995. There's no confession here akin to Hasbro. We say, to the contrary, there is a clear basis for the expansion into Europe, and indeed that was reflected in what was said in the Lidl judgment. The judge dismissed as mere assertions the matters that we draw attention to here, but as we point out at paragraph 56 of our skeleton, that won't do. When the question is the subjective understanding of Lidl, and you have material that shows that Lidl is stating what it thinks it is doing to an official body, no challenge to the veracity of those statements or their accuracy. They are, we say, only consistent with the entire pattern of the understanding that the use we were making was in a particular form and was acceptable. What they are certainly, we submit, is contrary to the conclusion that Lidl thought that the wordless mark was not intended for use, but purely there to offensively. Now, we think what happened is that the judge misunderstood what was said in this court, because when it came to it in the Court of Appeal, my lord pointed out, Lord Justice Arnold pointed out quite rightly, that although it was acceptable to explain that you were expanding into Europe, that would only work for one registration, not for all of them, because you then had to explain why 2005 and 2007 were done. But it does work for 2002. We say that that was a legitimate basis for seeking separate registration, and the judge failed to understand that, and as a result dismissed the 2002 applications in bad faith on improper grounds. 2005. This is the second community trademark, and the date, as I say, 3 years later. Can I ask you to take core bundle A and to turn up page 123, which is that chart of activity. Now, my lords will recall as to the intention to use the mark that we have seen only a few months before. Lidl has filed evidence at the US Patent Office with a declaration that it was already using this mark in the EU, and that this matches the same context and intention to use accepted by the Patent Office nationally in 1995. What then is the commercial context for the 2005 application, and should it have been taken into account by the learned judge? Now, we say that the specification here shouts loudly, because if we turn over to page 124, actually we should begin with the class overview. We're in the third column, my lords, and the thing you immediately notice is that these are registrations for services. That becomes important because as you scroll forward, you'll see that the column on goods is completely empty. There's no overlap there. You have to get down to page 130, and the first specification terms now show up in class 35, and they are for retail of foodstuffs, etc., retail services. Does my lord see it? It's quite tiny. It's just by the
135.
Sorry, 130. Class 35.
Right.
It's by the hole punch at the very top of the page. I'm not going to help my Lord Justice Burst, but
I've got it.
You've got it. Yes.
Yeah, but they are classes which are already covered, aren't they, by 2002?
Is the point that you don't have a registration for retail services?
Yes.
Right. Retail is detail.
Yes. Well, I think my Lord Justice Arnold knows where I'm going with this. 2005 was a significant date in the history of trademark registrations for retailers. My Lord Justice Burst is nodding as well. It marked a change in the law. That was the same year in which the Court of Justice handed down its judgment in Practica Bow. That decision is at Bundle B, tab 19, page 315. And my Lord's, given the nodding I'm seeing from the bench, I'm not going to take you to it because it sets out that it was possible to register for retail services. And the thing that I wanted to show you is that one of the advocates in that case, it's at page 317 in the bundle. He is a man called Mr. Schaefer, and he is the very same person who took over Lidl's representation in 2003. He's the person who signed the 2005 application. His firm indeed still acts for Lidl in trademark matters to this day. So what we are seeing here in the 2005 registration is that in response to Mr. Schaefer having obtained an expansion of the kinds of things that you can register for, his client then obtains a registration for the kinds of things you can now register for. What it is not, we say, is consistent with the idea of evergreening as pleaded, namely that we had only registered these marks because we were worried that we hadn't made use of them prior to this point. On the contrary, we think we had been making use of them, and now we need to protect them for a new set of services that we couldn't previously do. There are, it must be said, some sundry services in classes 39, 40 and 41. They're not duplicative of the previous services at all, but, my lords, I don't suggest you need to engage with that particular detail because the commercial explanation for 2005 5 is practicable, and it has not been taken into account by the judge below because she understood herself to have been set aside from consideration of that issue. There's only then one registration left. That is the 2007 application. Just pausing there to compare the dates. What you're not seeing is vast gaps of 5 years between registrations of previous marks and the next one. Indeed, the retail services application had been registered less than a year by that point, so there was no grace period pressure apparent from the chronology, although, as we know from some of the judgments I've taken you through, that fact alone is not determinative one way or the other. But what it isn't is timing consistent with the pleaded accusation of evergreening. What then is the commercial context, my lords? It is one of growth. Lidl's products and services have grown. Lidl's product offerings diverse by now as any supermarket in Europe, ranging from baked beans to inflatable boats. And again, there is some commercial evidence to show the context and the rationale, because in the course of the searches that were done, Lidl identified papers relating to this filing. Most of the documents were privileged, but one document was not, and that was a stock list of Lidl's non-food stock in the financial year directly preceding the 2007 application. And, my lords, my understanding is that the wrong document found its way into the bundles. I can hand up copies. Perhaps I might.
This is a document that was before the judge.
Absolutely. The error is that in the bundling for the appeal, the material has gone the wrong way. I gave this to my learned friend yesterday, but it's only come up now.
Do you tell us where this should go?
Yes, I am right in saying that it was. It was Mr. Unterhalter's Exhibit 41, and it should have gone Supplemental Bundle Tab 10.
Thank you.
Is that right? Yeah. It's in German, obviously, my lord, but the point that I'm drawing to your attention is that by this stage we are, for example, selling clothing. So now you have an analysis being done in the context of the application. What is my client actually selling? And therefore, what do we actually need to cover? And that is why there is a registration that now covers the new materials. So, for example, the one I draw your attention to is the addition now of Class 25 goods. And you can see that perhaps most conveniently.
Does the stock list include manure?
Does the stock list include manure? I don't know the answer to that particular question.
Maybe the evidence does not reveal.
It does. I don't know if it reveals that. What it does reveal, in my submission, my lords, what it does reveal, my lords, is that this is a party that is not registering willy-nilly, registering by asking itself, what do we actually need protection for? What are we actually creating or maintaining a market for? And then registering by reference to...
Yeah. Well, what about surgical, medical, dental and veterinary apparatus and instruments, orthopaedic articles? Are your clients selling those at that day?
My lords, it may be that the reason that those were registered is because, as you know, from time to time the stock changed and that was being covered. My point is not that this stock list you will find on this stock list everything that was then registered in these parts of the specification, but only that this is consistent with the registration being done by reference to there being the thought of a commercial rationale behind it. Namely, we're either doing this now or we might intend to do it in the future. Certainly, if it was to be said that in fact we had erred in the way that Skykick addresses, namely we had sought to register more broadly, then what the judge should have done is to send it into the detail and engage with those specific aspects.
Yeah.
You can see, my lords.
So you are entitled to register on the basis that you think you might be selling goods of this class, but if in fact you don't, then 5 years non-use and the specification will be cut down.
Indeed, and what I'm trying to do here is to show you that before the judge, was evidence of our subjective intention. And that's the crucial question here. What did we think we were entitled to do? It's not been done because it's defensive, because we haven't used it at all. It's been done because we've thought, we need this, we're doing this, we might need this, we might well do this. That's not the behaviour. It's certainly not consistent with a party that thinks to itself, this is just something we've got in the background in case there's a problem with our main mark. And for that reason, it should have been taken into account in a way that the judge plainly has not, because she has not engaged with that detail. And for that reason, although I accept that there are legal issues underlying this which inform why we say there is an error of principle at heart here that justifies your interference, really the problem is one of fact. Because once all this material is taken into account, unless you think you have already been constrained by that judgment at the interim stage, you would have engaged with this level of detail, and it is rationally insupportable to have then found that my client, having said it would use it in the way that it has used it, in the way that you have found that it has used it, is still to be held to have been proven to have acted in a commercially dishonest manner. My lords, I should stop there, and I'm content that the rest of my points are made clear in my skeleton argument, unless my lord has any final question for me.
Thank you very much, Mr. President. Yes,
My
Mr.
Lord,
Moses.
as you're aware, this is of little real interest to my clients. It was, has been, however, something that we have engaged with in argument below. We have filed our skeleton argument, which your lordships will no doubt consider. I was merely going to make a couple of brief points. The first is that as we understand it, this is essentially a challenge to an evaluative exercise by the judge, who was confronted with quite a lot of evidence, as you've seen. You've seen some snapshots of it, but certainly not all of it. The judge has carefully reviewed that evidence at some length in the paragraphs of the judgment between 248 and 260, and has reached a nuanced position as she finds what's established on the evidence as summarised in 259. Essentially, she has found that up to the 2007 application, which was ultimately granted in 2010, there was bad faith, but by 2021, when the most recent application was made, as she says in the last 4 lines, Liddell genuinely believed that the wordless marks had been subject to genuine use and were not vulnerable to revocation. That was 11 years after the 2007 mark had proceeded to registration. She says that's objective evidence of that, and then refers back to her finding that the wordless mark by 2021 enjoyed its own reputation for all the reasons I've already identified, and she has given good reasons for that. She's dealt with all the various points that my friends raised in the preceding paragraphs and reached that position. She's accepted there came a point where it's reasonable to decide that there was a genuine intention based on the fact that the wordless marks were being used by the mark with text, but that didn't exist in 95, and it didn't exist either in the repeated registrations 2002, 2005, 2007. It is a big ask, we would say, from my learned friend, to invite your lordships to take a different view and to pick a different date in time if the judge was right about 1995. Now, plainly, if the judge was plainly wrong as a matter of law or for whatever reason about 1995, then that would undermine her findings. But having made that decision in 95, well, against the background of a an increasing amount of use and a whole series of applications and complicated facts, we would submit that the rest of her findings are going to be extremely difficult to challenge. So far as 1995 is concerned, as we understand it, the matter certainly as I understand it, the matter came before your lordships, or two of your lordships, at the interim appeal. On that occasion, it was held that the pleaded allegations, which were of undeniable facts, I mean, it's not that the pleaded allegations of fact have been doubted, were capable of creating an inference.
Well, one of the pleaded facts was an assertion that the registration was for the purposes of using it as a legal weapon, as distinct from serving the functions of a trademark, and that was treated as being something that we had to assume was capable of being proved, given it was pleaded and there was no contrary evidence before the court.
Right.
So one's got to be a little bit careful with that particular allegation.
As we understand it, however, and certainly based on my learned friend's arguments, the reason it is said that what was actually pleaded wasn't able to found an inference is the fact that the Court of Appeal proceeded on the assumption that the non-use case was going to be decided in Tesco's favour. And my learned friend heavily relies on the fact that the judge has found in this action that the use of the wordless mark, the use of the mark with text amounts to use of the wordless mark.
And as I understand it, your submission is that that is incapable of retrospectively validating the behaviour in 1995.
Yes.
But as you've heard, one of the questions we've been debating with Mr. Browngrove is to what extent that's a factual question and to what extent it's a legal question.
Yes, and I think I'm to some extent dodging the question, but with my friend, that it is.
Is that allowed?
You have to view the legal proposition against the factual background, and what's going on here when one looks at the judgment, and when one looks at the matters that the judge ultimately took into account to find that there was acquired distinctive character of the wordless mark as a whole from the use of the mark with text, is that that was founded on massive use over a long period, having a huge impact, rather like Specsavers, on the public. And she made that point very clear in the judgment. In, for example, paragraphs 220, 221, which I don't know whether my own friend showed you, but this is the foundation of her finding on use. The very first point she makes is about the very substantial use over very many years. And of course, critically, the first store was only opened in 1994 in the United Kingdom. We're talking about 1995. So the idea that some massive impact has been had on the public by 1995 seems highly unlikely. And then the evidence she's relying on is expenditure between 2015 and 2020 on advertising, etc. She also, of course, ends up relying on the YouGov survey, which was carried out for this litigation. I don't know exactly what year it was, but let's assume it was 2021, something of that kind. So that again is ultra modern and reflects the usage and impact that has happened over the preceding years, and indeed all the matters down to the fifth point are modern pieces of evidence and plainly impacted by the very first point she's made at 220. Yes, she makes the point that there is some power of the elements without the word, but there's no finding that the acquired distinctiveness of the wordless mark itself, absent Liddell, such that it was effectively being used by Liddell when they used the mark with text, and the mark with text didn't affect the distinctive character of it at all. There is no suggestion that that could have happened without all the preceding evidence of historic use. So we say it's simply no answer to say, oh well, after the finding of use, that undermines everything that's gone before and all the matters that are pleaded as of 1995. We say it's essentially irrelevant. Malone and Friend would have had to establish all those facts as of 1995, and he never even tried to do so. So that essentially, we say, is the key point in 1995. What Malone and Friend then does is say, well, anyway, the judge had all this material, and we've looked at the Elkington and Fife letter, and we've looked at the Osmeroid. I'd merely say on that, the judge has looked at all of that in paragraph 248. She's reviewed it as a matter of fact, and she's drawn entirely reasonable conclusions. And in fact, one is tempted to say that when one reads the Elkington and Fife letter, it is quite hard to square with a suggestion of good faith, because here are people writing on behalf of their client to the trademark registry, simply stating the applicant confirms that it does have a genuine intention to use the mark across the width of the specification. Now, yes, of course, really they're talking about the specification. It's got nothing to do with any consideration of whether they're intending to use the mark or some variant. But the idea, they obviously had an opportunity to, given they were in correspondence with the trademark registry, to say, oh, by the way, you should know that we're not actually going to use what's shown here, but we're going to use this, and we say, in fact, it amounts to the same thing, and so on and so forth. No such statement is obviously made. And the Osmeroid material is even less probative behind tab 14. And the point there seems to be we have to assume that where it talks about using the yellow circle logo in combination with the name Liddell, that's talking about using the exact mark that's being used. I mean, it's an entirely general statement. Liddell could be placed anywhere, and it can't even begin to establish that there is even a statement here about using a yellow circle logo in the form in which it was actually said to be used. And the judge rightly dismisses that in paragraph 248. Apart from that, Malone and Friend takes a point about the statement of intention to use on the TM3. We say that can be no better. That's a necessity of any application, and it plainly is not the law that a mere signing of that form when one files the application is prima facie evidence of good faith. We submit that there's no basis for that, and the judge deals with that perfectly properly in 248 as well. So we say the judge has dealt with these points quite properly. That's a reasonable conclusion to reach on the basis of the fact that there was very little use and no evidence whatsoever of the real conception which is now floated by my learned friend, namely this idea that this is what Liddell actually thought, that the use of the variant would amount to use. And the judge did it all and come to the view that that state of mind did not exist prior to the 2021 application, or it could have arisen at some time between 2010 and 2021, but it certainly didn't exist until after 2010. She had to come to a view, she did. She looked at the evidence, and we say Your Lordship should accept that. My Lords, unless you think I can be of any more assistance, I feel you have.
Thank you very much, Mr. Purvis. Mr. Brandreth, do you wish to reply?
My Lord, there's no reply on what Mr. Purvis has said, but I realised that I did have and should have provided you with the translations that accompany
On the stock list.
Yes, indeed. And it does give me the opportunity to draw attention, at least, I think my Lord Justice Arnold asked about orthopaedic materials. You'll see on the back at the numbers 702, 703 and 704.
Just hang on a minute, so we've all got it.
Right. Too excited by the Court of Orthopaedic Materials. On the back at 702, 703 and 704, you've got consideration of bandages, elbow guards and sauna massage gloves. Now those, we're not suggesting those are orthopaedic materials. Bandages plainly are medical ones. But really it's an opportunity for me to show you that at this stage Liddell is dealing with these sorts of things, but also, alongside all the normal supermarket stuff, as you see throughout all of this, a vast and diverse range of goods. So for example, my Lord asked about manure, I think, and you do see that consideration has been given at 174 and 175 to the gardening materials that are already being offered, protective gloves for garden, hobby, planting vessels, etc., etc. We say that's why it was entirely plausible that they might be expanding their garden range to include the kinds of things like compost and manure that you would use. At the end of the day, I can only offer it to you for the submission that I made to you earlier, namely that it should have been engaged with in detail, because it was the explanation for why 2007 saw that expanded list. My Lords, that's all that I have to say.
Thank you very much. Well, thank you all very much for your very interesting arguments. We will reserve our judgments. You will get a draft in the usual way. It comes with a strict embargo, which means what it says, so it can only be shared with those on the distribution list, which we already have. It will be your opportunity to correct our English, but not our reasoning, and not to introduce new points. And we would hope that in the light of the draft judgment, you will be able to agree an order dealing with both the appeal and the cross appeal. If you can't agree a form of order, please make short written submissions, and we will make the order that we consider to be appropriate. The hand down of the judgment will take place remotely and electronically by email to those to the council and by release to the National Archives. Thank you all very much.